Welcome Jennifer Shaw, CEO President, Shaw Law Group, PC, presenting Reasonable Accommodations and COVID-19, Traps for the Unwary.
Thank you so much for having me. My name is Jennifer Shaw. I come from Sacramento. Today, we have offices in other places in the state, but I'm part of the Sacramento office. I'm really happy to be here. So we have a lot to talk about with COVID-19 and reasonable accommodations. I want to let you know we've got a lot of people who are streaming today. Welcome. If you have questions, just please send them and we'll make sure that I get those during the session. So I'll answer questions as we go. It's a little hard to see all of you because of these lights. So if I miss a hand, just holler up and I'll make sure I get you. I do a lot of these conferences. We're an employment law firm. So we do training, we do advice and counsel, investigations, all sorts of things. Conferences are my favorite because I get to focus on a little teeny important part of the law and hopefully give you all something that you can take with you. So remember that this is just intended to be a general overview. We don't have attorney-client privilege here today. So make sure that if you raise issues, you don't mention people's names, that sort of thing. And don't change any of your practices until you consult with your regular counsel. I don't want to step on anybody's toes. The lawyers have different approaches to these things. But I will tell you what you can do. And the question is whether you want to do it or whether your regular counsel thinks you should be doing it. All right. Does anybody have questions or comments before we get started? So here's what we're going to talk about today. First of all, I want you to think about reasonable accommodations, okay? We've all been familiar with reasonable accommodations for years, right? Because we accommodate religious beliefs and we accommodate disabilities. That is by virtue of both federal and state law, all right? Now, what got a little cuckoo for us in COVID-19 is the types of accommodations people want to have. Things like, I don't want to be vaccinated. I don't want to wear a mask. I want to work at home. So as you know, many of you probably took the position prior to COVID that people needed to be in the office, that remote work was not going to be successful. But when this pandemic hit in March of 2020, many of us sent everybody home because we wanted them to be able to do work. Now, were they doing their essential functions? Well, that's a question, right? And when we look at reasonable accommodation, it's a very important issue. But I want you to think about what your obligations are when you talk about reasonable accommodations. And then also the cultural issues that we're having, right? Vaccine hesitancy, for example. So somebody may not have a religious or medical basis for not being vaccinated. They just don't want to be vaccinated. Well, what legal protections do they have? Answer, none, right? That doesn't mean you're going to make people get vaccinated. Remember, nobody's dragging people down to the vaccine clinic to get them vaccinated. The question is, can it be a legitimate requirement for the job? That's just one thing that's come up with COVID-19. So I want to remind you of the basics for reasonable accommodation. As many of you probably know, these are the most expensive cases to litigate. They cost employers the most money, and juries award the largest verdicts when it comes to reasonable accommodation cases. So these are failure to accommodate. You didn't provide a reasonable accommodation, failure to engage in the interactive process, that dialogue that you need to have with your employees about what they can and can't do, also applicants, of course, and then disability discrimination or religious discrimination. So straight up, I'm not hiring you because you have you're differently abled in some regard, or you have some religious belief that I don't know about, or I'm not a proponent of. So when you look at disability accommodations, there's 4 factors for you to look at, right? Is the accommodation medically necessary? Is it going to be effective to get the person back to work to perform the essential functions of their job? Does it impose an undue hardship on the employer? And is there a direct threat? Okay, now, many of us jump right to the direct threat and the undue hardship analysis. We skip the first 2 prongs, but the first 2 prongs are critically important. If I tell you these lights are giving me a headache, right? And I say I want a 6-week leave of absence, is that effective? Is that an effective accommodation? No, because when I get back 6 weeks from now, they're still going to be there, right? So my accommodation request has to be effective to allow me to perform the essential functions of my job. We miss a lot. It's got to be medically necessary. When a doctor writes It would be nice if Jennifer didn't work past 5. Okay, nice or medically necessary? So I wish we had, 3 days to talk about this stuff because it's so interesting for me, but at least. But I want you to think about this, all right? Don't miss any of these elements. On religious accommodation, does the person have a sincerely held religious belief or practice? That doesn't mean it's one you've heard of, right? It's something they truly believe that is an issue of morality for them. It's an issue of what is right or wrong that they hold with the strength of traditional religious views. It doesn't mean it is a traditional religious view. And again, we've got the undue hardship analysis. So the first thing to understand is before COVID, you should have had a process for how to deal with these things. Most of you didn't because it wasn't a pressing issue. It didn't come up that often. With COVID, it brought accommodation to the forefront. And now we've had to figure out what processes, what procedures are we going to use to make sure that we can properly accommodate and that we follow the law in this area. Now, the first thing to understand is the individual, whether it's an applicant or employee, has to be able to perform the essential functions of the job. So if they ask for an accommodation that doesn't allow them to perform essential functions, it's not a reasonable accommodation. So if my job is receptionist, and I tell you I want to telework, okay? Some jobs of a receptionist probably can be done at home. But having somebody sit at that desk and greet the people who come in, that can't be done at home. So some of the essential functions of that person's job are not going to be able to be done from telework. Now, maybe during the pandemic, we allowed them to work at home because we didn't want to fire them. We figured we could find something for them to do. But now that people are coming back to work, the question is, can they perform their essential functions at home? So that essential function analysis is critical. Remember, you've got to define your essential functions in your job description, in your duty statement, whatever document you have that you're using to tell people, this is what I need you to do. I'm hiring you to do these things. Okay, and remember, there's a difference between essential functions and marginal functions. So if one of the functions of the receptionist is to walk downstairs and deliver the mail once a day, maybe if there's some disability or religious belief that would preclude him from doing that, he doesn't have to do that. That might be a marginal function. But answering the phone and greeting people, not a marginal function. Okay, so you've got to know the difference between your essential functions and your marginal functions. Now, the other thing you must do, if you don't remember anything we talk about here this afternoon, you must engage in the interactive process. And it doesn't go like this. Letter to Matilda. Dear Matilda, we got your doctor's note. This is the one thing we can offer you. Take it or leave it. Love, the employer. That is not an interactive process. I want you to treat these employees and applicants who ask for accommodations as if they are your favorite employee. And they may be, and they may not be. It doesn't matter. You're going to treat them as if you would do anything for them. They are your absolutely favorite employee. Whatever you would do for your favorite is what you're going to do for this person. By the way, why is that so important? What is the one thing we've got to be really careful about when we look at reasonable accommodations? Anybody? Got to be consistent. Now, is every case fact specific? You bet. But if you allow one person in the accounting department to telework and you don't allow another person, why is that? You've got to have a reasonable explanation, something related to their essential functions, right? Some reason why their jobs are different enough where one can do it at home, but one can't, or one can do it on the night shift and one can't. All right. So these are very important to think about from a protocol perspective. Now, the most important thing about the interactive process is that it is ongoing. So if Matilda says to me, Jen, I need a new schedule. And I look at her job and I say, look, Matilda, we can't give you a new schedule, but we could give you every Thursday off. Would that help? Let's say she needs time to go to a medical appointment. Okay. I don't know if that'll work, Jen. All right, we'll talk to your doctor and get back to me. It's an ongoing process. Also remember, and I know we all have desire for black and white rules, right? Somebody could be eligible for time off under, let's say, the Family and Medical Leave Act and the California Family Rights Act, or pregnancy disability leave and also be entitled to an accommodation. So my FMLA CFRA leave is I can only work part-time, but when I am here, I need to have frequent restroom breaks, or I need to have a special screen on my monitor. So I don't want you to think that, oh, well, we'll look at leaves of absence in this bucket and we'll look at reasonable accommodations in this bucket. No, they're all going to be happening at the same time. You've got to be able to bob and weave with them and make sure you understand what your obligations are. Okay. Also, please don't do interactive process in writing. Talk to the person. People say to me, well, they're working remotely. Okay. Do a Zoom, do a Teams, call them on the phone. I don't care. You can do a follow-up in writing, as we discussed today, XYZ, but you have to have that human component. You want to know what they're saying in the moment. By the way, what do you do if an employee says, well, it's too stressful for me to talk to you directly, so we need to do everything in writing? Do you have to agree to that? Answer quickly. No. I'm sorry, that's not how we do things here. So why don't you tell me a good time for me to call you, and I'll call you at that time. Or give me a good time for that Zoom and I'll set it up. Okay? Now, when we're looking at disability accommodations, I want you to understand that just about anything in California is a disability. The other day, somebody called me to say, oh, Jen, I've got this employee who wants an accommodation because she's having knee surgery. But that's not a disability, is it? I'm like, well, why is she having knee surgery? Because she's having a hard time walking. There you go. We got a disability. But she said it's not permanent. When she has the surgery, it's going to get fixed. I know that's not the standard. Permanent or semi-permanent. Okay, remember that pregnancy is considered a disability. Thank heavens it doesn't last forever, right? So it's permanent or semi-permanent, okay? The other thing to understand is I don't want you playing doctor. Anything related to a medical disability accommodation request is going to be dealt with a healthcare provider. Now that gets all sorts of complicated, right? Who's doctor? Who's paying for it? How do I do it? How do I get the information? What if Kaiser won't fill out my form? Okay, I know, but I want you to know it's all driven by a healthcare provider. And by the way, let me give you a little tidbit. If Kaiser won't fill out the form, you say to the employee, this is the information I need. I don't need the form. What I need is the information on the form. So if Kaiser's family visit verification report contains all that information, you're golden. If it doesn't, you write back to the employee and say, these are the two things that are missing. Get it to me in the next 5 days, right? Kaiser will do it. They won't do it the first time. It's like when you buy a car and you tell them the price you want to pay. They're not going to give it to you for that price, right? They're going to, you're going to have some discussion. Although these days, it's whatever they tell you you're going to pay, right? It's not like you're going to get a deal. Okay. Now, the one thing to understand is, and this is related to our essential function discussion a few moments ago, there's this phrase, qualified individual with a disability. I want you to understand what that means. What it means is that the person has to be able to perform the essential functions, right? They're not entitled to an accommodation if they can't perform the essential functions of their job with or without an accommodation. So that's an important thing to think about. So everybody is not entitled to an accommodation. If I tell you I'm having some medical issues and I'm going to need an unlimited amount of time off, and I don't know for how long I'm going to need it, you're just going to have to go with me here. No, I'm not a qualified individual with a disability. Now, a reasonably definite period of time that is brief in duration could be a reasonable accommodation in terms of a leave of absence, but not an open-ended leave, right? All right. Now, what are essential functions? The last bullet here is the most important. What does the person do? And I can't tell you how many times I've litigated these cases or given advice on these cases, and the employer gives me a job description, and I start going down the list, and they say, oh, they don't do that, they don't do that, they don't do that. Well, what do they do? You've got to have updated job descriptions. And COVID required us to change a lot of job descriptions, because we've done a lot of things differently, right? Many of you gave away office space, so everybody's working at home now. And things had to change because of that. Make sure that those job descriptions or those duty statements get updated. A lot of times, that's just sort of a ministerial process that we forget about. but it's real important that you've got an accurate job description to say what they're doing. Also, I want you to think of functions, okay? What are the tasks they're required to do? It's not an essential function to have a college degree, right? That's a requirement. That's not a task. That's not a function they're doing. And sometimes they're the most frequently performed tasks that somebody does. Sometimes it's just a really important thing that they're the only ones who know how to do, and it happens once a week, right? So don't be swayed by, well, they only do it once a week or once a month. Well, if it's really important and no one else can do it, it may be an essential function. All right, now, working on site as an essential function. This is a huge issue that COVID has brought up, right? Because for many of us, according to a recent study, about 80% of employers pre-COVID in California did not allow people to telework. Now it's flipped to 180. Now about 80% of employers in California are letting folks telework, and about 40% of them are mandating telework. They no longer have a brick and mortar office space, okay? So because of that, you've got to think about, as you sent people home during COVID and as you're bringing them back, and we're dealing with tons of clients who are having this issue right now. People are saying, hey, I know that I used to work in the office, but I've been working at home since July of 2020, August of 2020, whatever. And I want to still work at home. And we got to think about, look, is on-site work an essential function of the job? Do they need to be on-site? And I got to tell you, this challenges a lot of our stereotypes. I don't like people working remotely. I didn't miss one day during COVID where I worked at my house. I worked in my office. Many, many months, I was there all by myself because I told everyone else, do whatever you want to do. I'm not a good at-home worker. I'm super easily distracted. So I want to do the laundry, make some cookies, figure out what we're having for dinner, do a little online shopping, organize my daughter's closet, whatever to avoid work. So I got to be in the office. My tush has to be physically on site so that I know I'm looking at my pile of documents and my 1,000 emails and my 26 voicemails that came in the last hour. Okay, but I let everybody else do what they wanted. Well, now I'm telling everyone, I want you back. And what do you think they're saying? Well, why now? We were fine without it. Question?
So there's a question from online from one of our streamers.
Yep.
What are your thoughts on employers that only accommodate semi-permanent restrictions for 90 days?
Okay, I'm so glad the person asked that question. Okay, this is a gift to all of you. You will love me for this. Here's a lawsuit waiting to happen. If you only allow an accommodation for 90 days or 60 days or 30 days, and you have a workers' comp program, a modified duty program, where you let them do whatever they want on workers' comp, you have a huge legal problem, okay? You cannot limit reasonable accommodation prophylactically. You have to engage in the interactive process and decide what's reasonable. So even if you were to say, we'll only do it for a maximum of 12 months, that violates the law. Don't do that. And if you've got a modified duty program for workers' comp, you better understand that everything you allow them to do for modified duty, counting hangers in a retail store, whatever it is, you're going to have to provide that same accommodation for people who don't have an industrial accident or injury or illness. Okay, are you all following that? So be very, very careful. And by the way, workers' comp folks, I love them, but the carriers will tell you all the time, oh yeah, you can't fire someone on workers' comp. Want to bet? There's nothing in the labor code anywhere that talks about workers' comp that says I have to leave them on the books forever. They are treated just like non-industrial injuries or illnesses. Same exact way. We're FMLA CFRET. People will often say, oh, well, they had workers' comp leave first, and then I put them on FMLA. What? There's no such thing as workers' comp leave. If somebody needs a leave of absence, you figure out where they get that leave from the FMLA, from the CFRA, as a reasonable accommodation. Okay, are you with me? So push back when you hear that nonsense. It's not right. And I know why the carriers do it. I get it. I have great companies I work with, and they're trying to keep the mod rates down. They're trying to keep the premiums down. I get it. But that's not employment law. That's workers' comp. Employment law is something totally different. Okay? Now, Remember also that many folks who worked at home or teleworked during COVID, they weren't performing the essential functions of their job. We were just doing patchwork, right? We were trying to get all of the work done in the best way we could. So we may have let people work at home who weren't performing essential functions. And one of the things we did for our clients is we gave them an agreement back in March 2020 to give to their employees that said, you're going to be working at home, but guess what? You're not going to be performing the essential functions of your job. So when we're ready to get you back, you're not going to be able to argue that you performed your essential functions because these are the functions we know you can't do at home. If you didn't do that, that's okay. You just have to do the analysis now, right? When they're coming back or you want them to come back and they don't want to come, right? Direct threat. Okay, this is important. You know, there's a whole body of law about direct threat, right? So there's a series of cases before the California Supreme Court brought by a gentleman last name Accommodations. He was dealing with an oil refinery, all right? And they kept saying, we're not going to hire you on full time because we think the fumes will make your medical condition worse. He had a lung condition. And the California Supreme Court said, you can't just say there's a direct threat. You have to have specific medical information. Okay, so just saying, I'm not going to let somebody come to work because they may have COVID and they may they may infect us. Well, you don't know if they have COVID and you don't know if they're going to infect you. That's not necessarily a direct threat. Now, the direct threat analysis is important to COVID because certainly when you have someone who's a COVID-19 case, right, under the California Department of Public Health orders, if there's a close contact, there are things we need to do, right? And you all know that with the new rule, it doesn't matter if they're vaccinated or not. You got to get them out of the workplace, right? Until they have a negative result or 10 days have passed and they can come back to work on the 11th day. Obviously, different rules for healthcare providers, all right? But this direct threat is something that you're rarely going to be able to use, all right? Now, the other issue that comes up a lot is who chooses the accommodation. So when I first opened my firm in 2006, I had a lawyer who said he had a bad back. And I was pretty stressed doing a lot of stuff. And he said, could I get a new chair? And I said, yeah, just order a chair, right? I didn't even think about a process. So a couple of weeks later, this box shows up in our office, no joke, ginormous box. Our receptionist opens it up. It is the fanciest chair you have ever seen. It has, massaging and fancy leather and a radio in the back and these things that squeeze your calves like, woo, woo, woo. I was like, what is this? Well, you said I could get a new chair. I'm like, okay, that chair goes back. You're going down to Office Max and you're going to get the lumbar support chair. That's all you really need. Right? And by the way, if I have my way, it'll be green because that's your least favorite color. And we're going to have a little discussion about this. The bottom line is I get to choose the accommodation, but it has to be effective. Okay. So I got a note from his doctor. I was now thinking, right? I need a note from your doctor. Doctor says he needs lumbar support. All right. Where do you need it? I find a chair where he can get that. I buy him the chair. Okay. I get to pick the accommodation, but it has to be effective. So the employee, if the employee's doctor says, Jen needs to work at home or not work later than 4 o'clock because she has to take medication at 5. Okay, well, that doesn't mean she gets to work at home, right? That means we may choose that we're going to get you off at 4 o'clock. And that may even be an undue hardship. So I want you to be careful how you're thinking about who gets to choose the accommodation. And remember, if an employee rejects a valid accommodation, they're SOL. Right? Because if you didn't need the accommodation, then you're telling me you can perform the essential functions of your job just like anyone else without an accommodation. So get to doing your job. Right? So we have to know the rules so we can hold people accountable. Right? Now, undue hardship. This is your last ditch argument. It's very hard to prove undue hardship or undue burden. Okay? Particularly if you've got more than a couple of employees. Because you've got to show that it would literally alter the operations or the services you're providing, not just that it's a little bit expensive. Okay. So this is your last ditch effort. You're going to have to do a lot of analysis to figure out if something really is undue hardship, which is why I'm saying when you're looking at disability, figure out, is it medically necessary? Is it going to be effective? Is there a direct threat? Let's do all of that before we get to undue hardship. That's when we're going to actually figure out, okay, this is our last argument here. And I don't say that because you're trying to deny the accommodation. In fact, if you love these employees, which you do, you're going to try to grant the accommodation within the confines of what your program is, right? And what their duties are and what your protocols are. Okay. Now, religious accommodation is a little bit different. And there's a couple reasons for that. One of them is that with disability discrimination, we get a note from a doctor. Now, as you all know, there's Dr. All Say Anything, right? You can literally pay $25 online and just check like, I need a rheumatologist from, Costa Mesa to give me a note about X, right? And for $25, you get this great looking note. All right. Same thing with religious accommodation, right? When employers started dealing with COVID by saying, I want you to get vaccinated, all of a sudden these churches were popping up writing notes saying, oh, well, that would be against our religion to be vaccinated. And by the way, some religions have valid reasons where vaccinations wouldn't be appropriate, particularly depending on the type of vaccination, right? One is about to come out now that didn't use any fetal cells. So that's an argument that's going to go away when this new vaccine comes. Go ahead, Doll.
So another question is, if we need to do an undue hardship, how do we do an analysis?
Okay. How do we do an undue hardship analysis? All right. What you need to look at is what is going to have to change if you grant this accommodation. Let me give you a very silly example, but it'll show you what I mean. Let's say I tell you I have a skin condition and I get sunburned very easily. So I need to work at night. So I want to come to work at 8 p.m. and I want to get off at 3 a.m. Okay. Now, I'm a non-exempt employee. So first of all, should I be working alone in the building from 8 p.m. to 3 a.m.? No. So we're going to have to figure out, do I have to get somebody else in the building? Oh, and now I got to turn on all the electricity, right? Because electricity would normally be off, but now I got to do, extra hours of turning on the lights. Oh, by the way, now I have to actually pay extra for our air conditioning and our heat because normally those are running from 6 a.m. to 6 p.m. But if you're going to be here in the out of regular office hours time, we're going to pay extra for that. You've got to look at all that and say, okay, is this an undue hardship? And in that case, it is. That case has been litigated where a court said, yeah, for you to have to hire a second person and spend all this extra money, that's not going to work. Let's figure out another way. And by the way, what do you think the alternative accommodation was? Can she telework? Right? Now, there's all sorts of issues that come up with teleworking in terms of reimbursement requests and how much you have to pay for internet. And, there's a lot going on there. But understand that's how this works. Go ahead.
Another question is regarding face mask mandates being lifted. If some employees request masks to be worn for indoor meetings, can we force all employees to wear masks as internal policy?
Okay. Can an employer require everyone to wear masks? Yes. Unless somebody says, oh, I have asthma, and when I wear the mask, I can't breathe. Or I have a problem with my ear, and when I wear the mask, it causes my ear to do something, right? Like if there's a medical reason why, then they may be entitled to an accommodation. But yes, employers can do that. Employers can say everybody has to wear masks. And the whole mask psychology is really interesting, right? Because some people think masks don't help at all. Other people think masks help a lot. I think the science is kind of mixed. But my own view is, how could it hurt, right? I mean, even if it saves a couple of droplets of something, maybe that helps. But I'm no doctor. I don't know what I'm talking about. But if I decide in my office, which I did, if you're unvaccinated, you're going to wear a mask. People didn't like that. I was like, well, sorry, that's what we're doing. Because we've got vaccinated people who are in the office. They want to be here. If you want to come in and you're not vaccinated, I don't care if you're vaccinated, you're going to have to wear a mask. So yes, you can absolutely do that.
All right, so this one is regarding religious accommodations.
Yep.
If we gave religious accommodations for religious reasons for vaccinations, as our agency requires, can we then require the employee to get the new vaccine that did not use cells when it is available?
Yes. What they're talking about is the new Novavax vaccine, which is not going to use fetal cells. And so the whole argument about I can't use any product that has fetal cells. By the way, y'all may not know this. Baby powder, shampoo, toothpaste, a lot of it's been tested with fetal cells. Okay. So when people say, oh, I can't take the vaccine because it's been tested on fetal cells, even if they're 30 years old, a long line of fetal cells from 30 years ago, that argument falls apart if they don't know, oh yeah, well, there's all these other products that are tested on fetal cells and I won't use them either. But yes, if that's the basis for the religious exemption, that their religious belief precludes them from using any product that is in any way relying on fetal cells, the new Novavax will not have that. And that will change things, which is why, good lesson, you never grant an accommodation indefinitely. I give them for 90 days. Here's an accommodation for 90 days, we'll reevaluate. Because you don't know what can change. Their job can change, a new vaccine can come out, a lot of different things can happen. Okay, so it's a great question. All right, I have an employee, they worked a shift, I'm making this up. They work shift A, 8 to 5, and now I want to put them on shift B. Can I do that? Yeah, they're at will. Now, what's their recourse? I don't want to work for you anymore. I'm done. Peace out, baby, I'm done. I'm not doing shift B, I'm doing shift A. So I want to be clear, we're not literally dragging them to shift B, right? We're saying we're changing the terms and conditions of your employment, and you get to decide whether it's acceptable for you. Now, if you're in a union environment where there's been a post and bid for a shift and shifts are assigned based on seniority, you won't be able to do that. But you got at-will people, you can do whatever you want like that. Even a different job. If they don't want it, they don't have to take it. This is like rest breaks and meal periods, right, folks? But I don't want to take my rest break and meal period. Okay, well, here's the deal. You're going to take it or you're going to be without a job. So you have 5 seconds to think about it. What's your decision, right? It's like my daughter. Did I negotiate like, well, if you want to play in the street, I'd rather you not, but if you want, no, you play in the street. I'll pick you up by your bottom and drag you to the house and you'll be sorry that ever happened. Guess what? She never played in the street. And she would tell grownups when she was 3, no play in the street. That's right. There'll be no play in the street. All right, go ahead.
So another one is, if you have an employee who went out on a personal leave, came back to work without modified duty or accommodation, and continues to not meet essential business finances, can we begin the termination process?
All right, I think
you're an AR clerk.
Yeah, here's what I think the question is. Somebody's out on a leave of absence and now they come back to work. They have no restrictions, but they're not performing well. You're afraid to fire them. You're afraid to manage them because of a retaliation claim, right? You're thinking they're going to say, oh yeah, sure, I just got back from leave and now look what you're doing. But here's my word of advice to you. You manage you manage top to bottom the way you do every day, whether it's someone coming back from leave, someone who just had a baby, someone who's asked for an accommodation, it doesn't matter. Once you start trying to figure out, well, I better not hold that person accountable because they asked for this, and I better not do this for that person, you're creating all sorts of inconsistency problems. Don't do that. You're going to say to that person, hey, Matilda, here's our expectations for you. You got to meet them. Doesn't matter that you just came back from leave. And even if you have an accommodation, you still got to meet our expectations, right? Remember, that's what makes somebody a qualified individual with a disability. So religious beliefs are very broad. We've talked about that. What makes a religious belief sincere? Well, you got to ask questions, right? Did you just develop this religious belief? It can still be sincere. Do you have to have a letter from the leader of your church or your religion? No. Remember, a religious belief is a moral or ethical belief about what is right and wrong that is sincerely held with the strength of traditional religious views. It doesn't have to be a traditional religious belief. You're going to get very little out of questioning the sincerity of somebody's beliefs. You want to go instead to, all right, what is going on here in terms of what does this person want? Now, when it comes to COVID, the answer is a little bit different there, right? Because sincerity does matter. If you're telling me I can't get vaccinated because I refuse to use products with fetal cells, and I ask you, as I have done for numerous employers, okay, well, do you know any other products that use fetal cells? No. Well, when did you develop this? Oh, a couple months ago. Well, so you take the Novavax vaccine, right? Because, when that comes out, no, I don't think so. We're done, right? Because you don't have a sincere belief at that moment. And there are very valid religious beliefs for vaccines, for all sorts of things. But I want you to understand the sincerity matters. It's just hard to ask questions about it, right? So if you're unsure about somebody's belief, you can ask for additional information. But pretend, and hopefully this is true, they're your favorite employee. Only ask those questions that you would ask of the person who you think walks on water, all right? Now, remember that religious accommodation is something that eliminates the conflict between the practice that the employer has and the religious belief. So let me give you an example. This came up a lot because I've done a ton of COVID religious accommodation issues. So the employer says, I want you to get vaccinated. And the employee says, I have a religious belief. What's your religious belief? God says I can make my own decisions about what to put in my body. Okay. You don't have a valid religious belief for the purposes of this issue, because where's the conflict between that and getting vaccinated? If your God says you can be vaccinated, it's your choice, then where's the conflict? Right? So this is a really important issue. And this is something you're always going to want to deal with legal counsel about because it's tricky, whether it's your in-house counsel or out-house counsel. But the bottom line is you want to really think about, okay, what is the conflict between the employer's practice and this religious belief or practice? That is always the fundamental question. And you certainly can't segregate people. So you can't say, oh, well, if your religious belief is you need to, not be near someone who has COVID because your religious belief says you can't take medicine and therefore you're more vulnerable, you can't put that person off in a separate part of the building. Right? No segregation under California law for any reason. So you got to figure out how to deal with it elsewhere. But when you look at reasonable accommodations, when we talk about religious beliefs, it could be schedules. It could be somebody saying that they don't want to wear a mask or they don't want to get vaccinated. People have tried to say it's against their religious belief to be tested for COVID. That's a real tough argument to make. What's the conflict between your religious belief and getting tested? Don't get me wrong, okay? There's a lot of valid philosophical reasons why someone may not want to get tested or may not want to get vaccinated or may not want to wear a mask. But those are not protected. It's religious beliefs and disabilities that are protected. Yes.
So this one is asking, an employee has a permanent restriction on driving, and as a result, the work schedule was adjusted 6 months later. The employee states that he is no longer driving to and from work. Can he be asked to bring a new medical note?
So so here's the question. We've got an employee who has a restriction on driving and he gets a different shift so that it can accommodate that. I think that's what's going on. Now the question is, can we get a different note? Can we get an additional note? Yeah, we can get notes anytime somebody's need for accommodation changes. Or if they told you they needed accommodation and now they come and say, I don't now, we need a note that says that. Because as long as we have your note on file, it's last one on file that counts, right? So as long as the most recent note we've received says you need this accommodation, we're going to make sure that we get a note that says otherwise. Undue hardship is different than it is for disability discrimination. It's not, thank you. It's not as hard to establish, but here's what you can't do. You can't say, oh, if I give Matilda this accommodation, everyone else with her religious belief will want it too, so therefore I better deny Matilda's. You look at them case by case, one by one. Now, if you've given a lot of people an accommodation and then another person asks, it may be an undue hardship to give that last person the accommodation. But this is how methodical I want you to be when you do this analysis. Okay, you've got to go step by step. Now, if you're going to ask questions about religious beliefs, make sure you've got a legitimate reason for it. It's not your prurient interest, right? It's not just you're wondering, ooh, how does this happen? We have a little issue going on in our neighborhood right now where a couple's getting divorced and now we're seeing like the girlfriend's car and the boyfriend's car and everything. So another neighbor came over yesterday and she was like, Jen, have you noticed that car is, and I said, okay, I really want to know this, but I don't think we should talk about this, right? Like there's a family being torn apart now and probably don't need those details. It was interesting, a lot more interesting than what I was doing at the moment. But I said, yeah, no. And she agreed. We decided, no, let's just not play into this. So as much as you may want to know, it's got to be something you actually need the information about. And also remember, you're trying to solve the problem. This is an employee you love. So you ask things like, gosh, I don't think I could do X, but would Y work? Let's talk about why wouldn't work, or why wouldn't work. And remember, the employee will often say, this is it. This is all I'm having, nothing else. Take it or leave it. Yeah, it doesn't work that way. We can't do that. And the employer, the applicant, can't do that either. Now, when we talk about special issues in COVID-19, we've talked about these. Vaccinations, these are all the potential vaccination accommodations you might consider. Some people get long haul COVID. That is a disability. So you're right in this reasonable accommodation side of things. Pregnancy, remember, you've got to deal with. Pregnancy has been more challenging with COVID because people are put on bed rest sooner, or at least taken out of the workforce because of the risk to the fetus. So that's something you've had to deal with. Folks will say, well, I need an accommodation because I live with someone who is very fragile and they have a tough medical condition. Not going to be something they're entitled to accommodation for. Remember, we get accommodation for our own condition. There's not an accommodation for someone else. Don't assume that someone 65 or over needs an accommodation, right? That's called age discrimination. There are people under 65 who need it and people over 65 who need it. And you know that we have COVID-19 sick leave. It's going to expire at the end of the year. It's complicated for sure. A lot of this is beyond the scope of our discussion here today. We've talked a lot about working remotely. Basically, what you've got to do is you've got to have a methodology. You've got to have a process for what you're doing. So I know we have a couple more questions. Let me just finish this. Some of you have asked about our podcast. We have a Workplace Wake Up with Jen podcast. It came out of our Wednesday Wake Up. So you can look at that. We've got some webinars coming up. Let's talk about other questions you may have. Anybody? The question was, could we? Not do we have to? No, you don't. You don't.
If the company policy isn't that we have to do masks.
Right. However, it is very, very important not to mistreat the person who's wearing the mask. So no jokes, no comments, nothing inappropriate, right? That's all got to be very clean. People who choose to wear masks need to be absolutely respected. I think I saw, yes, go ahead.
Well, hi. I have an employee who, per Kaiser, has a longstanding medical condition that makes him susceptible to risk of COVID.
Yep.
And has requested a remote work arrangement. Due to continued performance issues, even during COVID, the supervisor determined that remote work is not it's not something that they can support.
It's not reasonable because it imposes an undue hardship because they're not doing their job.
Okay. And it's not ADA protected because the risk of COVID is not under.
Well, hold on though. Remember, in your situation, the employee could get a medical condition. They've already got something that makes them more susceptible. So they probably do have a disability. It's just not a reasonable accommodation, right? If they have performance issues and they're not performing the essential functions of their job remotely. So you see why the analysis is so important. You've got to be really methodical through each step. Okay, other questions? Yes.
To add to that question, does the substandard job performance should be documented, right?
Yes, please document substandard job performance. People call me all the time like, oh my gosh, Jen, he's like the worst employee ever. And they're going on. And I'm like, send me the documentation. And there's like crickets on the other end of the line. Like, do you have any documentation? Well, we got a new supervisor. I know. It's not that it's illegal if you don't have documentation. It's just you've got to prove your case. Remember that the burden is always on the employer. All the employee has to say is, I was treated unfairly. Now it's your job to prove that wasn't the case. So it's not required, but you better have it, right? All right, what else?
In your professional opinion,
Yes.
would you recommend a policy of vaccination?
Oh, that is such a good question. All right, let me tell you what my answer is. And lawyers are, always like, if this, if that. So this is going to drive you crazy. But here's my answer. And I really believe this. I think it depends on the workplace. If you're working with a bunch of elderly seniors who are very, if they get COVID, it could be life-threatening, much more than the rest of us. I might say that everyone should be vaccinated, even if you don't have direct patient care. You working in a school, right? I represent a ton of schools. They all had mandatory vax policies because they want to protect the kids. In my office, did I have a mandatory vax policy? No, because I let people work at home. So if you can work at home, I don't need to have a mandatory vax policy. My own beliefs are that I try to dictate as little as possible to people. I feel like there's like manifest destiny and they should be able to make their own decisions. But there are some things that you have to protect people from themselves. So, yes, in appropriate circumstances. All right, everyone, I want to thank you so much for your time and attention. I had such a great time with you. If you want to be on our newsletter list, just leave me your card up here. Don't forget to tune in for our webcast. And I just hope I see you guys soon. Be well, drive carefully, enjoy the rest of the conference. Thanks, everyone.